Okay, well, why don't we go ahead and get started then. And for anybody who's listening in, just wanted to make sure to call your attention to the fact that if you want to listen in addition to just seeing what we're talking about, then it's going to be very important that you dial into the code and number that I've just circled on this slide. And if you have any colleagues or friends who you think might need to know that they need to dial in, then please, again here, just highlighting that to listen into the program, you'll need to dial into the access code, which is listed on the screen. So welcome everybody, and good morning or good afternoon for those in other time zones. My name is Mike Droke. I'm delighted to have you here. I am particularly delighted to be talking today with my partner, Robert Hensley, who, as you'll hear in a moment, is the El Jefe of our Food, Agribusiness, and Cooperatives Practice Group. Dorsey & Whitney is a global law firm. We have 19 offices around the world, including offices in Washington, D.C., Washington State, we call the other Washington, California, New York, Canada, Denver, Shanghai, London, truly a global firm around the world. I myself am a partner in the food and agribusiness cooperative, practicing both in the kind of corporate area for co-ops and also in the employment area for management teams and employers. Today we've got a new format which is designed to be a little bit different than other programs that you might have participated in from lawyers. And a quick shout out to my client and friend, Jennifer Keegan from Vegetable Grower Supply, who helped come up with this idea. What we're going to do, instead of trying to shove 75 very dense, text-heavy slides through the internet at the people who are kind enough to listen in, is that we're going to have a more of a discussion about an important topic that's happening in the food and agribusiness world, namely GMO, genetically modified food products and the like. And we'll do it based on the new statutes and regulations that are coming out, but also in more of a discussion format. So at the end of the program, you're going to receive a survey, and we really encourage you to review that survey and to give us feedback both on the substance of today's presentation and also on the presentation format. We'd love to hear from you. Now, this time we're going to do something a little bit different than we have done in previous programs. Namely, we're taking this topic and we're exploring it in two different ways. As we'll hear again at the end of the program, today's focus is going to be on business issues in the area of GMO and looking proactively at what the regulations are and what effects they have on food-related businesses from a business perspective. And then in about a month, we're going to have another presentation. Again, I'll give more information about that at the end of the program, where we'll look at the litigation risks associated with labeling and GMO to talk about the impacts on what happens if you get it wrong. So, Robert, could you give a brief overview of your background?
Sure. Good morning, everyone. I'm a business lawyer, and I've been representing food companies for nearly 30 years. As Mike alluded to, I'm co-chair of our Food and Agribusiness Industry Group, and I'm also co-chair of our Cooperative Law Group. I'm a partner at Dorsey. I split my time now between our Minneapolis and Denver offices. As far as what I do legally, I spend most of my time counseling food companies on issues related to processing, manufacturing, marketing, and the sale of food products.
Terrific. So as we get started with our discussion, I want to involve also those who have logged in. You'll see in the screen in front of you that there's a chat pane in the lower left-hand corner of your screen. And if you have any questions as we're going through the program, then please don't hesitate to identify the question in that chat field, and I'll make sure to either weave it into questions we already anticipate covering or also to ask it as we're going along in the course of the program. If you'd like to stay confidential, then please identify that you'd like to be remain confidential. On the other hand, if you don't care that, I use, for example, Grant Lundberg. Hi, good to see you on the screen here. And if you don't mind me calling you out individually, and that would just make sure I identify that as well in the chat pane. So with that, I was just fascinated. This morning I went down to Starbucks, got my Starbucks coffee and my oatmeal, and I kept thinking about the fact that a lot of the food products that we eat have been bred over time. The oatmeal is a certain flavor, a certain texture, color, and the like, and they've been bred over time to have certain characteristics. And so now we have this concept of GMO, and I just found it interesting as a concept and a topic. I'm a West Coaster. I grew up in California, have resided in Seattle for a very long time, did a lot of work in Portland and along the West Coast. Very high degree of customer sensitivity to this issue on the West Coast. Robert, why were you so interested in this topic?
I've been working in this area for nearly 30 years, and I frequently sit at board meetings with clients where they discuss should they go GMO in their products or label or not go GMO, and really involved in those business issues. And so I picked the topic because a few months ago, one of those board of directors of a client asked me to give a presentation about GMO issues, and rather than make it a legal presentation, I did a lot of research and gave that presentation in June of this year, but it really focused on market type of issues. And in doing that research, I came to some personal conclusions about where I thought the market was headed, just based upon being involved in it for 30 years. And the passage of the new federal legislation on labeling, to me, confirmed those conclusions. So I thought it'd make a good, more general discussion topic for those in the industry.
Now one of the things we say yes, no GMO. I think almost like a cheer. Yes, no GMO. What is it to be genetically modified?
That's actually part of the new legislation has that definition in it of what is genetically modified. So people use the word GMO, genetically engineered, genetically modified. I don't use them in precise scientific terms. I use GMO a lot because that's the way people generally refer to it. The new legislation that's out uses the phrase genetically engineered. But when you're really looking out there at the world, over 80% of U.S. foods are genetically engineered. So there's quite a bit out there. And if you look at corn and soybeans, nearly all corn and soybeans are genetically engineered.
So what do you mean by genetically engineered in this context?
In this context, it's really gets down to a definitional issue where you have something where a gene has actually been modified in some way in the product. And that's one of the things that the new legislation both tries to clarify and muddies the water on. But it is interesting. There's been some studies about it. Even though 80% of U.S. foods are genetically engineered, there was a study about 2 years ago from the Pew Research Center that 57% of consumers believe GMO foods are unsafe.
Yeah, that's definitely true in Seattle. I can tell you that. When I go to whatever store, it might be obviously, sometimes we've got our local co-op that specializes in selling natural products and the like. And I find often charges a premium either at whatever store that you're at for those kinds of products. But it's kind of hard to tell from a consumer perspective.
Yeah, I think one thing that's an interesting, there's scientific realities, and I understand those. But then there's also consumer concepts and what consumers believe. And my belief is consumers are extraordinarily confused about all of these issues. What's natural, what's genetically engineered, what's organic. I believe the majority of consumers don't understand the differences between them. Earlier this year, the National Academy of Sciences published a 400-page report on genetically engineered food. Dozens and dozens of major scientists signed on to it, and the study found there was no evidence of health risk for humans from genetically engineered food. and there's no risk of horizontal gene transfer from genetically engineered crops to humans. But even though that study came out, that study was really pretty quickly denounced in the media as being corrupted by agribusiness companies, and that science quickly faded into the background.
For those who are listening in, by the way, we will be referencing periodically some source material, and if you're interested in getting more information about that, at the end of the presentation, Robert's contact information will be there, and you're more than welcome to reach out to him directly as well to get copies or links to those types of resources. Now, just focusing on the products that we have here, can you give just a quick practical explanation about what the how these products were genetically modified rather than kind of bred over time to have certain characteristics?
It gets really into the definition that's in the new statute. Whether you're using in vitro techniques to deal with the DNA and to insert a protein or other genetic material, and that's really what the general marketplace, when you're looking at agribusiness companies, make the differentiation between conventional breeding methods and genetically modified methods, which involve some type of placement of other material into the gene of a product. So I think there's a lot that look at some of the new definitions in the statutes and say it's so vague that maybe not sure what that means anymore. But historically, it means some type of modification of the genetic material in vitro or in a laboratory type of setting rather than through conventional breeding methods.
So where did the regulatory structure start? What was the beginning process?
It's almost it started as the consumers, and then became a marketing issue for the most part. But there were several states that looked at passing laws, and the industry came out, and there was quite a bit of money spent to campaign against the passage of those laws in California, Oregon, other places. Vermont passed a statute, and that Vermont statute that was passed was going to go into effect in July of this year, and it with a 6-month grace period. And so that Vermont statute really got the industry's attention, and it provided that there were really 3 label requirements based upon the content of genetically engineered material by weight. And you either had to label partially produced with genetic engineering, maybe produced with genetic engineering, or produced with genetic engineering. And it mandated certain font sizes that would be printed on the labels. And you couldn't use words such as natural, naturally made, naturally grown on the labels. And of course, that got the industry's attention.
It seems to me from a business perspective, that's kind of like the tail that wags the dog, right? If you have one jurisdiction that has such requirements, and you need to have a nationally recognized or sold product, then you really have to take the most restrictive common denominator into account, right?
Yeah, that's absolutely true. I mean, what you started to see in the marketplace is the major food companies believed and stated, we can't make special labels just for Vermont. So they started to label food sold throughout the United States to comply with the Vermont law. So I'd go to Minneapolis and pull a box of Cheerios off the shelf, or Fritos or whatever it would be, and they would say partially produced with genetic engineering or produced with genetic engineering. If I bought something in Minneapolis, so the major companies were labeling to comply with the Vermont law no matter where they sold the product. You're starting to see that more and more.
And so what do those terms mean? Like partially produced with genetic engineering, what's that supposed to be?
Well, under the Vermont law, which of course is now preempted, partially produced with genetic engineering was defined as less than 75% genetically engineered material by weight. So it tried to quantify that. And then if the ingredient source varied, then you could put the statement, or had to put the statement on the label, may be produced with genetic engineering. So it sort of depended upon the content and the weight, which one of those 3 you picked.
And then you have the scarlet letter, which is produced with genetic engineering.
Yeah, maybe to some. To a lot of consumers, it's a price point. And to a lot of consumers, and I argue a growing band of consumers, it's not so much a price point. It's a health and safety, or a perceived health and safety issue. Let's say it that way.
So, the question, what happened to the Vermont law?
Well, I've got this slide. It was called the Dark Act, and I don't use that phrase, but I think it's out there so much that you can make the connection, and that is it was called the Dark Act because the new federal legislation basically left consumers in the dark on whether or not something contained genetically engineered material, because you could use QR codes like you see here on Obama's head. But what happened is back in July of 2015, the U.S. House passed a federal labeling bill that would have preempted the Vermont statute, and it took about a year of lobbying, but the Senate eventually developed another version of the bill, and this summer Congress passed a new law, and it was signed by President Obama. And that new law preempts any state law, meaning states can't pass any genetically engineered labeling laws.
So, what is this new statute? I guess the first comment I had was that it's fascinating when you're looking at 1946 era statutes that are trying to be applied in a 2016 and going forward world. And has this Marketing Act been amended frequently during that time period?
Yeah, there's been countless amendments to the Agricultural Marketing Act, and so the new statute I refer to really isn't a new statute. It is an amendment to a statute that's 60 years old or so, the Agricultural Marketing Act of 1946. So there are provisions of that act that that have been amended.
And then you also referenced that the statute, the amendments, require the Secretary of Agriculture to establish national disclosure standards. So does that mean that the second shoe hasn't dropped yet?
Yeah, the second shoe is a way off, and it is one of the criticisms of the statute, and I think there's some valid criticism, is it's pretty vague, and I think Congress does that a lot of times intentionally so that agencies have a lot of leeway in their rulemaking and regulation making process, so they have hearings. But the statute specifically mandates that the Secretary of Agriculture, the USDA, has 2 years to come up with some new standards for disclosures related to bioengineered foods.
So what are the key steps that companies have to contend with here?
Well, yeah, as I go through the legislation, I sort of categorize it into 7 buckets for the most part. So, bear with me as I kind of go through these 7. And I've read this legislation countless times, and every time I read it, I find some other little nugget someplace that I puzzle about. The first one is it prohibits any state from passing laws about genetically engineered labeling. The second is it requires the Secretary of Agriculture within 2 years to establish a national mandatory bioengineered food disclosure standard. The third is it prohibits the regulations from concluding that food derived from an animal that is fed a bioengineered substance is a bioengineered food. And so if you feed a cow GMO corn, the regulations can't conclude that cow, just because it ate bioengineered corn, is also bioengineered. Fourth, it requires the USDA to establish a process for requesting and granting a determination that food is not genetically engineered. So this is going to be a very interesting process because now food producers are going to be able to go to the USDA before they go to market and ask for a determination from the USDA that the food's not genetically engineered. And an interesting part, and this is going to be really interesting and a part of our next topic a month from now, and I'll touch on it, it provides that food that has successfully completed the pre-market review process shall not be treated as safer or not as safe as a non-bioengineered counterpart solely because the food is genetically engineered. So that's going to be really an interesting process out there. You can claim it's GMO-free, but you can't claim, I believe, that it's safer than something that's GMO. Fifth, it requires that the form of disclosure be a text, symbol, electronic, or digital link with the disclosure option to be selected by the food manufacturer, and that's obviously been criticized. That's one of the more criticized aspects of the act by those that want more detailed labeling, I'd say, because the food manufacturer gets to pick the type of label, and it could be an electronic or QR link of some sort. But then the sixth item deals with that same topic, and that is the USDA has 1 year to study and identify potential technological challenges that may have an impact on consumers and whether the consumers can have access to those electronic disclosures. And if the USDA determines after doing that study that consumers would not have sufficient access through electronic disclosures, the USDA can make food companies provide additional and comparable options so that the consumers understand the genetically engineered disclosure without referring to the QR code. So there's going to be a lot of process in the next year or two to go through to sort through that. And then the seventh item, and that's the last sentence of the law, if a food is certified under the Organic Foods Production Act, a federal statute, then the certification shall be considered sufficient to make a claim regarding the absence of bioengineering in the food, such as, so if you get an organic food certification through the federal statutory process, you automatically can claim that the food is non-GMO.
I feel like exhausted already.
There's a lot there, isn't there?
And truly, each of the seven, you could do a whole hour presentation on any one of them. It seems
At least.
So, talk a little bit about the statutory definition of that are in the regulations.
Yeah. So the statutory definition is really it says that it's a food, refers to food that contains genetic material that has been modified through in vitro recombinant, here's my lawyer rather than scientific pronunciation, but it's dioxyribonucleic acid, DNA techniques. So it contains genetic material that's been modified through in vitro DNA techniques. And then it adds, for which the modification could not be otherwise obtained through conventional breeding or found in nature, which is an interesting modification because you can claim that, well, if we did this long enough, we could get this same end result product through conventional breeding methods. We just accelerated it by using DNA techniques.
So that's fascinating because really what you're talking about is kind of changing a little bit that if you had somebody who was a food scientist who was designing, either doing genetic modifications or other kind of engineering relating to food, then this adds a new component to the thinking, it seems to me, of that scientist to be keeping a log or taking into account from a scientific perspective what the steps would have been to achieve this without the science.
Yeah, I mean, I think you could have people trying to go through the USDA pre-clearance process to have so that they don't have to label as GMO, making claims and backing that up somehow, saying, okay, even though we did produce this through in vitro DNA techniques, we could have done this over a 30-year period of time through conventional breeding methods. We just accelerated it so it's not bioengineered under the statute, so we shouldn't have to label.
And then, what is, from a practical perspective, if you know, what is an in vitro recombinant DNA technique?
Yeah, after talking, you read certain things about this on the internet and news sources and others, and there's in vitro and in vivo. In vitro basically means you're doing it in a laboratory in a test tube, as it's been explained to me by a PhD in biology. So
fantastic. And then, what information can you give us about the concept of the disclosure standard? What are you hearing so far out there generally?
There are going to be some exemptions that are under the statute. So, very small manufacturers and restaurants are going to be exempted. Foods where meat, poultry, and egg products are the main ingredients are going to be exempted. There's not going to be a labeling requirement for animal meat solely because the animal meat is fed GMO corn, for example. Other than that, it's pretty dark right now on what the labeling standards are going to be. I mean, if you just look at the statute, if you are a manufacturer, a food company, you could put a QR code on there and not even use the word genetically engineered, as I read the statute. Whether after a year and the final regs allow that, I think that's going to be a subject of a lot of congressional, a lot of hearings at the USDA and a lot of submissions and a lot of letters.
And it strikes me that you've got a brand challenges too, that if you use a QR code, that if I'm a consumer who's aware, which is a lot of ifs, I guess, but then I would look at a QR code that does not have a product saying it was GMO or non-GMO, and I would assume that meant that it was genetically engineered over time.
Yeah, I mean, I think it's going to raise a lot more prominence on other types of labeling that goes on. The butterfly GMO project designation and things of that sort. So you're going to see things on the label. I don't think you may or may not see something similar to what the Vermont law says, or you may see just QR codes and the absence of any real affirmative statements that are in English on the label.
What's specifically not covered?
The definition really focuses on the end product, I believe, and I think that's what a lot of people believe. So it's not that and I believe what the regulations are going to come out, but who knows? It's going to focus on the end result of the food, not what the food came from. And so I can use the oil as oil is processed, whether or not that actual end product contains any genetic material that would indicate that it was genetically engineered. Sugar is a good example. Sugar can either come from sugar beets or from sugar cane, but at the end, it's all the sucrose molecule, and so you're really creating something new in the manufacturing process by creating the sucrose molecule. So if you take sugar from genetically engineered sugar beets, but then make sucrose out of it, there is no genetic material contained in that, of any type, contained in that sucrose molecule. So you would look at that and say, well, there's no labeling requirement because the end product, the sugar, doesn't contain any genetic material at all, let alone any genetically engineered material. It's just simply a molecule.
So stating the obvious, that GE here is not a General Electric, right? It's genetically engineering.
Yeah.
And I notice you have question marks behind these. Why is that?
Well, I think the Secretary is going to have a little bit of discretion. And this is an unusual statute because it says in some places, that the regulations have to have certain provisions in them, but generally the courts give the agency some discretion when it comes to, okay, here's a definition, here's how we're interpreting that definition or that word that's used in the statute, and so I think there's room for the regulatory process to fill in some gaps, add some color, some details, and things like that. And one of those is, for example, there's some thresholds. So the Secretary could say, pick a number, anything de minimis. What's de minimis? Anything that contains, say, less than 5% or 1% of the genetically engineered material doesn't have to be labeled. And the Secretary, probably has that discretion to say, I'm going to establish some de minimis process so that for a food manufacturer that has one line and runs some non-GMO and some GMO through the same line, and you have all, cleanup and everything you're trying to do, the argument has been, well, if there's even just a tiny little trace of genetic material that is genetically engineered in the non-GMO, what's the result of that? And so I think it gives the Secretary some discretion in those types of thresholds.
Well, I'm really reminded of the situation we had out here in my region with wheat, where it was essentially a non-GMO producer had wheat that was blown over onto their field from neighboring farms, and as a result, traces came out, and it caused an incredible uproar.
Yeah, so that's something I think the regulations will probably deal with, and that'll be an interesting topic to see how that comes out. I already touched on it, food that could potentially be made from conventional breeding methods, but is actually genetically engineered. That there's actually, the Secretary, I think, will hopefully clarify that in the regulations. There's some interesting parts about how the law applies. What's not covered is the impact of violating the law. The statute simply states that it shall be a prohibited act for a person to knowingly make a disclosure required knowingly not make a disclosure required under the statute. So it's a knowing standard. It's not a strict liability standard, and it doesn't state what the penalty is, whether that's criminal or some type of regulatory penalty, fine, or what it might be. So the regulations are going to have to deal with that somehow.
Well, I'll make sure and ask Chip Maggott, our partner, on September 14th, that question, right?
That'll be a good one. The other one is the Secretary of Agriculture doesn't have, specifically in the statute, doesn't have the authority to issue a recall for any food subject to the title to the statute on the basis of whether or not the food bears the required disclosure. So if the food is supposed to say it's bioengineered and it doesn't, the statute specifically says that the Secretary of Agriculture doesn't have the authority to issue a recall. So presumably that falls to the FDA.
Exactly, for false labeling or the like, right?
Yeah.
Interesting. So I'm kind of interpreting here what's not covered, and it seems like it falls into a couple of categories to see if I'm getting this right. First, there are some that are specifically excluded, perhaps, from the statute. For example, you described that the cow that eats genetically modified corn would not be covered by way of statute. And then you have some that they can show that it would have been bred to, ultimately you could have achieved this result through long-term breeding, and this was an acceleration. And then third, you had this kind of bucket of things that are kind of genetically modified by nature of their own product, like sugar, for example, or possibly soy. And then finally, we have a discretionary bucket where the Secretary of Agriculture might determine that, from a practical perspective, there's some threshold where you have to say it's non-GMO, even if there might be a trace in there. And then the question is, what's the trace?
Yeah, and Mike, there's an interesting subpoint on that, is that there's this other category in the statute, and it says a food may not be considered to be non-GMO solely because the food is not required to bear a disclosure that the food is bioengineered. So, I'm not quite sure what all that means either, but I think it means that the Secretary has some discretion in saying, okay, you don't have to label it as genetically engineered, but that doesn't mean you can also label it as non-GMO.
Wow, it's full circle right there, huh?
It sure is.
Designed by lawyers and legislators, so that's always interesting. So when you think about what people should do next, what are the strategic questions that?
I think from the standpoint of marketing materials, this could be very, very significant. And by marketing materials, I think it's going to apply differently to food companies and food processors versus what I call the nonprofit advocacy groups that are out there, like the Center for Food Safety and others. So the statute has a really interesting provision that I don't think you could really make a claim that non-GMO food is safer than genetically engineered foods. And there's specifically a provision in the statute, and I kind of have to read it almost. It says, a bioengineered food that has successfully completed the pre-market federal regulatory review process shall not be treated as safer than or not as safe as a non-bioengineered counterpart of the food solely because the food is bioengineered. So, I mean, the phrase safer than or not as safe as, I think creates, there's a lot of vagueness there. But you could certainly, I think, take the position now that if I have a product, I've gone through the USDA pre-market process that they're going to put in place, and they say that I don't have to label and somebody else out there has something that is non-GMO, I think they could label theirs as non-GMO, but I think that other food company has to be really careful about saying we're non-GMO and we are safer than that other product. That word safe or not in the phrase not as safe as leaves a lot of room for interpretation.
Yeah, I mean, I'm focused as someone who litigates a fair bit too on the idea of solely because. So it seems like for sure you could not say GMO and therefore we are safer than non-GMO.
Yeah.
Like that would be prohibited by the statute. But that if you had good quality control mechanisms that meant that you took a lot of steps to make sure that the product was safe from contaminants, had the information, you had the source product in it that it claimed, and the like, then you could make a claim of safety for reasons that were kind of other than GMO, and also have non-GMO on the label.
Yeah, I think it's going to create. I mean, there's a question of whether this creates some type of private cause of action for a company that says, you can't, because you're non-GMO, make a claim that your food is safer than our food. I think there's a lot that needs to be developed with regard to what that provision means. And so I think food companies and their website material, their other marketing material, are going to have to be thoughtful of what that means and what the regulations ultimately say. But I don't think it's going to apply to the advocacy groups like the Center for Food Safety. I think this applies to food claims and labeling claims. It's not going to apply to the nonprofits who say genetically engineered food is bad and unsafe.
So if you have non-GMO food, then to some degree, those advocacy groups are helping your brand anyway.
Yeah, you just have to be careful about not endorsing them.
Well, that's a good point, because then that's implicit that you're making the claim that because you're non-GMO, your product is safer.
Yeah.
Interesting challenge. One of the questions I had, bullet point here says, will the new law and regulations matter? And I was thinking that from a slightly different perspective. That let's say I'm a producer and I'm already marching forward with the Vermont law because I don't want to have to put a new sticker on it. I want to make sure that we're labeling appropriately. What are the kinds of things that this new law? Obviously, the new law trumps the Vermont law. It sounds like, right?
Yep.
But what would I do differently if I'm already kind of heading towards compliance with Vermont or already in compliance with Vermont?
Well, you don't have to comply with Vermont. The statute basically says that, and it expressly preempts those laws as of the date the statute was signed by President Obama. But I think you have to be looking down the road of what's happening. So, whether you want to still voluntarily label or not, even though there are no regulations, the statute's in effect. But I think you have to look at, whether you want to voluntarily label your product or not. I'm not sure if it's going to make a lot of sense to voluntarily label that your product contains genetically engineered material. But what I do think is it's going to lead to more and more prominence of what I call third-party verification services. That it's going to be a more and more common to see those little stickers, emblems, symbols, whatever they are, that say something about your food being organic or GMO-free or whatever the case may be.
Got it. And conversely, you're not going to be required to put on there that you are producing with genetically modified.
Yeah, you're not. The statute right now. There is no requirement that you make that label. It's going to be up to the Secretary of Agriculture over the next 2 years to decide what the requirements are. So we're sort of back to where we were before the Vermont statute went into place.
Perfect. So that kind of answers my question, I guess. That if I was really all ready to go to say label things as partially containing GMO, then I probably do not have to do that anymore, correct?
Yeah.
And then, the concept of does marketing trump science, what do you mean by that?
Well, it's, if you look at these consumer polls that are out there, the Associated Press did a survey in 2015, and 66% of Americans favor requiring food manufacturers to put labels on food that say it's grown from genetically modified organisms if it is. So, consumers want to know, and that's, again, this is Robert's view of the world of marketing out there, but, speaking from, talking to clients, but also from going to the grocery store, the marketing buzz is our food is organic, our food is not genetically modified, our food is natural. All of those labels being thrown at consumers, whether consumers understand them or not, have a big impact. So as you go through the grocery store, you're not going to see people market, it's genetically engineered. You're going to see people market that something about the food is better for you, either an implied statement or an explicit statement, because it's organic or non-GMO or natural.
It's interesting, as candidly the parent of two millennials, I hear this at home, and even this morning one of our colleagues said, boy, it's scary what you put in your body. And that could be a Seattle-based West Coast perspective, but there are some big markets out here in the East Coast and wherever, where that kind of market perception is strong.
Yeah, one of the bullet points here is, will the market for GMO-free reduce demand for GMO foods? And you just have to look at, there's only so much shelf space in the grocery store. And 5 years ago, you had to sort of seek out a specialty grocery store, a local food co-op, the Wedge in Minneapolis type of store, and seek them out. And now you go to Costco or Walmart or Whole Foods, and the labeling systems are, not just dealing with whether or not it's organic or GMO-free. They're also dealing with the how the food was grown on the farm and reaching back to those practices through some type of ranking system. So all of that is making consumers more aware of not just what's in the food, but how it's grown, reaching all the way back to the farm. And there's only so much shelf space. So what you had to really seek out a few years ago is becoming more than half of the produce aisle in regular grocery stores now.
It's fascinating for those who are listening in from other parts of the country. If you've never watched the show Portlandia, there's a segment there. If you literally look on YouTube for Portlandia Cage Free, I think you come to it, and the segment goes that the two actors are at this restaurant, and they want to learn more about the food, and they want to make sure that the chicken they're about to have was cared for on the farm and lovingly fed, and they then take a trip out to the farm to make sure to confirm that the farm was appropriately managed, etc. And obviously it's a spoof, but it does indicate some of the consumer preferences that are out there, that the customers care and they change their buying habits as a result of what they care about. And when that happens, you have price changes and demand changes on the farm. So how do you think that's going to play out when you say that? How big will the price differential grow?
The price difference is both what you're seeing on the shelf, but you also deal with farmers, and farmers drive a lot of this. Seed companies drive a lot of this because both the GMO corn and soybeans were both originally marketed as, it may cost you a little bit more because of the fees you have to pay related to buying the genetically engineered seed, but you're going to save time, you're going to save on chemical costs, what you have to apply. And one of the arguments, though, that's out there, and the study that I talked about earlier that was put out by the National Academy of Science says one thing they have found is that over time, there's the hockey stick effect with regard to chemical use on farm. That originally the chemical use on farm was reduced because of genetically engineered crops, but because of resistance, it's been increasing over time, and that's those studies show that it's actually higher than it was before there was genetically engineered crops on farm. I'm not saying that's true or not. I'm just saying there's studies out there that say that. There are also studies that are done by the USDA that compare crop yield differences between, say, organic and conventional, and that obviously there's a higher yield for conventional than there might be for organic just because of agronomic practices, but that the price of organic, but the net returns are higher for organic. Now, you can argue that's a specialty market, and if more farmers get into that specialty market, the price differential will go away because of basic economics. But there are more and more pressure as more food companies put pressure on saying, well, we're only going to take certain types of products. I talk to farmers and they say, we actually think we could grow non-GMO corn just almost as efficiently as we could grow GMO corn. I'm like, really? And they're like, yeah, we could. We don't want to, but we could. But they could do it if the price is right for them. It's all about a net return on farm.
So those, certifications, I've got a list here of several of them, can make a difference as far as the branding on the farm. And then obviously the market forces make a huge difference, because if you have, substantial producers, manufacturers, value-added producers who need the non-GMO qualifying products into their products, then that increases the price based on common economics, like you said.
Yeah, first, touching on these symbols, I think if Congress had mandated certain types of disclosures, that everything had to be, that contained any genetic material had to be clearly labeled as contains genetically engineered, material, the stock of those organizations like the non-GMO Project might have gone down. But now I think the stock of those organizations has gone up, because if you can label organic or you can label non-GMO, because of that verification process, I'd argue that this may be a boon to those types of verification organizations. But yeah, back to your original question, Mike. I think what market forces are in play in this debate. I strongly believe the majority of consumers don't understand the science or the issues. What's the difference between natural and GMO? If you're on the phone and if you haven't watched the Jimmy Fallon YouTube interview of people on the street about what is GMO, it's worth 90 seconds of your time. It's pretty humorous because people don't understand it. The marketing and the advocacy will always be there. There's a lot of big players out there that have said they want to label, and it's hard to market it contains genetically engineered material, but it's easier to market it's natural, or it's non-GMO, or it's organic. I think that's going to be continuing to see. We're going to see more and more of that.
That's just fascinating when you think about the changes that have to happen to get those things to market. On the farm, I talked to one farmer, for example, who was raising organic milk, and the process to achieve that was pretty extraordinary. Multiple years of changing the feed and having certifying organizations come in to kind of have the non-organic cows ultimately convert into organic cows, I suppose, for purposes of at least the branding of his milk. So it takes a while and a pretty substantial investment out on the farm, it seems to me.
Yeah, and it depends on whether it's row crops or animal farms. 3 years for row crops generally, or that for plant agriculture generally. So it does take time, but at the same time, it's the difference between. It doesn't take much time to go non-GMO. It's just a matter of making sure you have the seed, and that's just genetic material as opposed to growing organic. But I think either way, I'm not sure consumers understand the difference between GMO-free and organic. I think there's a lot that equate them as the same thing.
Yeah, I frankly would. If I didn't know more information through programs like this, I would think they were essentially the same thing. When it sounds like, in practical terms, from a farmer perspective, you could move towards being GMO-free as part of a step towards getting certified organic.
Yeah, it's like a baby step toward a giant step, in my opinion. So.
Yeah, fascinating. So, there's a lot that is still will remain as part of general law and the like. But tell us, what are the implications of the new law moving forward? What are your predictions?
Yeah, I think it's basically the end of the Vermont law and other state laws regarding genetically engineered labeling. It's probably not the end of mandatory labeling. I think that the USDA is going to come out with some type of labeling standard. I'd be a little bit surprised if the labeling standard says you can just use a QR code or a 1-800 number. That's going to be the big fight of whether or not it's something that really is fairly close to the Vermont law, or whether you can just put a 1-800, for information about, the contents, call 1-800 or scan this code. So that's going to be the real fight. I personally think it's going to come out that some type of written labeling in English is going to be required, but, who knows? I think
Can I ask you a question on that, Robert, just for a sec? Are there organizations other than the USDA that could stick their fingers in this, like the Federal Trade Commission or others, to say, listen, based on the statute, if you don't identify, through mandatory labeling, you're committing a false, trade practice or the like?
I haven't looked at it from that perspective, but I think that would be a long shot. I think it's going to mostly end up between the USDA and the FDA, and I think the two of them are pretty confused about who has what jurisdiction. But I think hopefully that all gets sorted out.
Interesting.
I don't think this is going to be the end of other label verifications, such as the non-GMO project and those. In fact, I think it's going to be a boost to those types of label verifications. It's probably just going to further confuse consumers about what it means, because it's going to be a 2-year process, and you're going to see all kinds. There's dozens of different verification labels that are out there, and it gets to be pretty confusing. It's just going to add to the confusion that's out there. And I think the third-party verifiers also need to be careful about making misrepresentations about what their verification actually means. So they all have websites too, and I think they have to be careful about, okay, we're gonna give you the stamp, but I think you have to be careful about on their own website saying, well, this means it's safer or better. They're not food companies, but the food companies are putting that on their label. So I think you can make the tie that it all could be a safety claim of some type, and they got to be careful of that.
Yeah, they're a defendant in litigation potentially if they need to make sure that their procedures, sampling methodologies and the like are appropriate from that perspective as well, it would seem to me.
Yeah, I agree.
So, fascinating. So in other words, not the last we'll hear on this particular topic, for sure.
It's going to be 2 years of process in front of the USDA.
So if you're a manufacturer or a producer, what are the best ways to kind of keep yourself reasonably informed without hysteria, on this topic?
We've got our practice group puts out e-alerts and other types of alerts about it. So, that's one way you can do it. Certainly you can subscribe to the USDA's information services. I subscribe to the FDA. They're all free. So every time the FDA issues a new food-related regulation, they automatically send you information. But obviously, if you want that more distilled, we have an e-alert, and you can subscribe to our email list, and we'll send those to you.
Fantastic. And so that people know where to go, that would be go to www.dorsey.com and look on the food and agribusiness practice, and you'll see not only Robert and Bridget Hayden's wonderful pictures, but in addition, a little link where you can sign up for our e-newsletters, and we encourage you to do that. And then the FDA website is www.fda.gov, and is also, as Robert mentioned, a terrific resource for folks that stay on top of the law. Okay, so Robert, with that, any final thoughts on this topic?
No, I think we covered just about everything I had to give you the 30,000-foot overview.
Terrific. So a little bit then of information for everybody. As I mentioned, we've got all kinds of credit that you can get for this program, including continuing legal education or other types of credit. So you're going to get a survey at the end of the program here. It'll be sent to you by email. That will have the certification information that you need for CLE. And we also really encourage you, again, to complete the survey both substantively on the topic that we've talked about today and also on the format. We're very interested in your feedback. And then, of course, if there are other issues that involve the law that you think are really interesting or important to your business, we encourage you to let us know that on the survey as well so that we can look at future programs and topics that are of interest to our clients and friends. And then, as I mentioned earlier, on September 14th, we've got the second in this particular sub-series of the interactive dialogue, which is what we're calling GMO Labeling Part 2, which is, okay, so let's say that you either have some products that are already in the stream of commerce and they're not, labeled quite in the way that you're thinking they should be now under the federal statute. What does that mean? What kinds of litigation theories could be brought by creative litigators on this particular topic? And to address that, we have one of our own creative litigators, Chip Magid, who's a partner and the head of our D.C. office, Washington, D.C., who will be talking about the product liability components of GMO labeling and the liability risks associated with that. And as always, we'll be addressing some practical ways that you can help limit your exposure, move your exposure by way of indemnities to other people like the ultimate the initial producers and the like. So we'll be addressing all those types of issues. And if you have specific questions on that topic, please don't hesitate to let either of the three of us really know, either myself, Robert, or Chip. You're welcome to contact or let us know any specific questions that you have. And so with that, we are very grateful for everybody's participation. I know I speak for the whole firm and our 250 or thereabouts lawyers who are part of the food, agriculture, and cooperatives practice to say both, first, Robert, thank you for the great leadership that you and Bridget give to our team. And second, to the clients and friends who've dialed in, we're very grateful for your participation and for your trust in Dorsey and Whitney. So with that, and seeing that we have come to the end of our time, thank you again for participating. I see one person's already sent a thank you, a very helpful overview of the new law. We always love that kind of feedback. So have a great day, everybody, and thank you for participating.